Helen Rella is a member of Wilk Oslander's Global Practice Group, advising corporations, individuals, and governments conducting business in the U.S. and abroad. Helen has substantial experience in labor and employment law, representing both individual and corporate clients. She is an expert at developing and implementing appropriate personnel policies and procedures and defends clients against discrimination claims, as well as challenges in court and before the Equal Employment Opportunity Commission, state and city divisions of human rights, and the U.S. Department of Labor. Welcome to the RiskAdvisor.com podcast. I'm Sal LaFury, and I'm here with my good friend and co-host, Jim Henry. So today's topic, we want to talk about returning to work after COVID-19, something that's in everybody's mind today. So Jim, over the last few months, we've both seen some serious innovations taking place with respect to technologies and how they're being implemented. You know, some of it's been really good, and some of it, I mean, as we joke about a lot of times, it's just downright stupid. Me and you, we've seen all of this before, right? The World Trade Center bombings, the 9/11 attacks. And we see that the technology drive that came from all of that, and a lot of technology was really good. Now we have the COVID and we have legal implications that seem to be greater than ever. What do you think about what's happening now between the technology drive and the legal implications that are popping up?
Well, you're right. We have seen this all before. And when you say, some of these implementations or ideas have been downright stupid, that's from the perspective of the practical application. But when you look at the people that are peddling these, may not be so stupid because they're driven by blind or mercenarily driven opportunism, I should say, and it's a vulnerable clientele out there right now. They're very concerned. They're looking for a quick solution. And some of these ideas are very nicely packaged and presented generally to the C-level management, where the vulnerability is most of greatest concern. And it bypasses the normal vetting that would occur, when you don't have an environment, like we have today. And again, we had it post 9/11 with a lot of the technologies that came out, and a lot of product and a lot of technology was bought, but the implementation did not meet the expectations that were created by the artful salesmanship of those manufacturers. So, hopefully we can get quickly past that and be deploying solutions that truly, reduce the risk and our practical application of technology.
Yeah, I think it kind of goes along with what we had been talking about earlier today when we were talking about how some of these technology companies that are creating these technologies are just jumping over to security director folk and are going directly to the CEO, CFOs, and coming out with a shiny new toy and trying to get them to buy it. And the director level is getting this stuff down their throat, saying, hey, here's a new toy, try and use this, make this work. It's even worse when there's the relationship, when it's the guy's brother-in-law that's bringing it to bear. But aside from that, and we see this on almost, a daily basis now in the consulting practice. So to talk about some of the legal complications about returning to work, we have with us today a special guest who also happens to be a close personal friend, and that's Helen Rella. Helen, welcome to the show.
Thank you for having me join you here today on the Risk Advisor. I'm honored to be your guest. At the outset, I would like to say, of course, our discussion is in the context of information only, and this is not legal advice. And certainly anyone who has any questions pertaining to any of the subject matters that we discuss should seek the advice of independent, competent legal counsel.
So, probably the first thing that draws everybody, when you think of an attorney, you think of the next topic, and they come hand in hand, is fear, right? So what are some of the employee fears or the employer fears or employee fears that you're hearing on a daily basis? What's the most common things that you're hearing today?
Well, the element of fear really comes into play in the discussion relating to the coronavirus because that's the excuse that many employees are giving in saying that they do not want to return to work. In fact, what we've seen is that there are a lot of employees who are not going back to work and using that as a justification. Unfortunately, fear is not a reasonable basis to give an employer for not coming back when the employer says we are, in accordance with state guidelines, opening our offices and we expect our workforce to come back.
So the employee gets to set the terms and conditions of employment wherever that
employer.
work is done. The employer.
The employer sets the terms and conditions of employment. That's right.
So what happens if a person refuses to go back to work?
If
Or is
some-
making a claim? Does that become discrimination of some sort, or how does that all apply?
If somebody refuses to return to work and they have not requested what's known in the law as a reasonable accommodation under the Americans with Disabilities Act, asserting that they have some sort of medical or physical, mental or physical condition that prevents them from coming back to work, and they're granted an accommodation, absent that, they can be deemed to have resigned and their employment can be terminated.
Does that impact unemployment insurance?
Yes, because if you quit your job, you're not entitled, generally speaking, to receive unemployment insurance.
And I mean, some of the topics that we've been hearing, some of the stories we've been hearing, employers are having a very tough time getting employees back
Correct.
because of the unemployment insurance.
Well, that's because there's a federal kicker of $600 on top of the rate that an employee would be entitled to receive from their state, whichever state they're in.
That's part of the CARES Act.
Right. In some instances, what we have are situations where employees are making more money now per week, collecting the base unemployment rate that they get, that's calculated in accordance with what their pay level was, and in addition, receiving that $600. So that is a problem. That's a problem. In fact, we saw employers who received PPP loans who were unable to get their workforce back because those loans are largely predicated on keeping the workforce intact. And so employers who laid off or furloughed their workers said, hey, come on back. We want to have you come back and we're going to pay you with this loan money that we've gotten, which is a requirement for the loan forgiveness. We're put in a position where the employees are saying, sorry, we're not coming back because we're making more now collecting unemployment insurance. That's why you hear on the federal level of discussions of potentially some sort of an incentive to get people to go back to work.
So Helen, a number of employers now have authorized or are permitting, their employees to work from home. And in some cases, there are some costs associated with setting up, to work from your home. What is the situation with regards to an employer's obligation to compensate the employee for some of those expenses?
There is no obligation for an employer to pick up the cost of a home office. So employees certainly can engage in interactive discussion with their employer, and what we're seeing is that employers are cognizant of the fact that some people might need assistance, and many employers have provided, at the outset of the pandemic, employees with laptops, with cell phones, where their calls are routed from their office phones to the cell phone so that they can continue to work. And employers are trying to assist in that regard because it's in everybody's interest to have people working cooperatively together. But there is no affirmative obligation on the part of the employer to pick up those costs.
All right. When we were talking about fear initially and what the position is of some employees with regards to resisting coming back to work, you indicated that reasonable accommodations, they can make requests for reasonable accommodations in case they have underlying medical conditions or whatnot. Can you elaborate on that as to truly what their rights are and what the employer's responsibilities are to accommodate them?
Well, under the Americans with Disabilities Act, somebody that has an actual condition, right, a physical or mental condition that impedes one or more basic life activities can make a request for a reasonable accommodation. But in fact, the request has to be reasonable and it cannot subject the employer to undue financial hardship. If it does, that's a basis for the employer to deny the request. The request has to be considered in an even-handed, non-discriminatory manner across the board. And in the case of COVID-19, we are seeing people with comorbidities, which is that phrase that indicates you've got some sort of a condition where they deem you to be more at risk, and that includes being over 60, having a heart or lung problem, high blood pressure. You've heard the talk of obesity. All of those things are qualifying conditions that would give an employee a basis to make a request for an accommodation. And the employer, again, would then have to look at those requests in an even-handed, non-discriminatory manner.
I'm assuming you would suggest that both for the employer and the employee that these requests and the communication on the accommodations be done in writing between the two parties?
Well, look, there always is a writing when there's an accommodation request that's actually gone through in terms of medical documentation, et cetera. But typically speaking, employers should feel free to speak with their employees about these things when the employee comes to them and says, "I would like to make this request." Because people need to work cooperatively together, particularly in this situation where we're dealing with a pandemic and situations that we haven't had to address before.
Right, but even when it's a congenial relationship, I think it'd be beneficial for the employer to have the optics of showing that they're dealing with these requests in an even-handed basis.
Of course,
Yeah.
of course. And we always recommend that everything be documented in the employment setting. And there's a whole series of paperwork that has to be completed.
Is there like an arbiter that can be, or like a mediation or somebody in between? Because it appears the employer has the ultimate say, and if the employee feels slighted, then the next step is legal action.
Well, that's unfortunate. That's something that we don't like to see happen. In terms of whether there's an arbitration regarding a request, that you would only have that come into play if you had somebody that had an employment contract that mandated that any type of dispute be sent to arbitration, or if you're dealing, for example, with a collective bargaining agreement with union employees, and then there would be a whole host of procedures that would have to be followed. But generally speaking, accommodation requests go directly from the employee to the employer and are addressed by the employer. Usually the first step is the Human Resources Department of the employer.
Sounds good. Okay. Well, I just want to remind the listeners that you're listening to the Risk Advisor podcast hosted by Jim Henry and me, Sal LaFreri. We're going to invite you to comment on our blog at theriskadvisor.com and to subscribe and follow us on our social media like Facebook, Instagram, and Twitter. If you're interested in having one or both of us speak at an upcoming event, or you would like to consult with either one of us or both of us, please go to our webpage again at theriskadvisor.com, and you can set that up. So, Helen, one of the things I'd like to get into now is to talk a little bit about issues that we can anticipate employers are going to be facing in the terms of future claims that are going to come up. There's a whole liability, a whole laundry list of things that potentially can happen. One of which I think is going to wind up playing, and I may be wrong, and you can tell me, wrongful death. Somebody who's gotten COVID and who winds up dying from it. What's the potential for those lawsuits to come back?
The problem that we have in this area, Sal, is that there is no way to definitively prove where somebody contracted the virus. People don't live in their office space, so the notion that you could make a claim that you got this at the workplace, it does not seem probable from a proof perspective. Generally, on-the-job injuries are covered by workers' compensation. Workers' compensation law deals with those types of claims, and employees are limited to that basis. Unfortunately, in this instance, we find that the workers' comp carriers have made it known that they are not going to be covering these types of claims, and that is again because there's no definitive proof as to where you contracted the virus. Can people bring those claims? Do we think they'll bring those claims? People bring all sorts of claims against their employer. I wouldn't anticipate that that's going to be the largest area. I think there's a greater likelihood that we're going to see discrimination claims relative to accommodation requests that are denied. We also may see claims that pertain to those that were selected for layoff or termination. It claims that was done on a discriminatory basis. There might be wage and hour claims for people who are hourly workers, not salaried, meaning that they're compensated on an hourly basis and that they're working from home and are not being adequately compensated for overtime. Those are the types of claims that we anticipate, but it's going to run the gamut. It largely depends as to whether or not the legislature is going to pass some regulation that limits or prohibits the claims under COVID-19.
So we hear a lot about denial of leave. That seems to be a very complicated issue, somewhat maybe under FMLA, but government saying, the New York State at least was saying for a while, you can, if you don't feel good, you can stay home and you can't be charged against your time. Explain some of that or clear some of that lunacy up for us, because some of it just is awfully confusing.
Well, there are a whole host of regulations that were passed on the federal level relative to people who became ill with COVID-19. So an employer cannot terminate somebody if they're subject to an order of quarantine and they have the virus and they need to remain home. In addition, there are provisions under the law, under the Families First Act, that provide for leave for people whose child care facilities or schools were closed. That's mitigated now by the fact that we're now in June and schools are already closed, so there's not that issue that comes into play.
How much does OSHA play into all of this?
OSHA it regulates hazards, right? Is a hazard. Occupational safety. We usually only saw OSHA getting involved in workplace type claims. An example that I can give is when somebody who works at a chemical plant where there's a hazardous substance that's being that's being produced and employees bring safety related claims. That's a very good example. That's easily understandable. OSHA implications, I think, are going to rise because the CDC regulations use the word hazard and reference an employer's duty to prevent against it. So that's going to be interesting to see how that plays out. We don't know because the return to professional offices is really only just beginning. And so once that moves forward and the claims begin to be filed, which we anticipate they will be, we'll have a better understanding of what laws people are going to be making the claims under.
So we may see a correlation between those kinds of hazards in the workplace and maybe an employer that is not really adhering to the protocols that the state and local governments are enacting. Is that an area where those claims actually may get some footing? Because you said earlier that it's difficult to prove where you got it, but if you have an employer that is ignoring or not adhering those guidelines, could it even carry to the point where you might even have a wrongful death claim as a result of
I would say that anything can happen. It's fair game now. It's fair game. Because we've never had this experience before, we don't know what's going to happen, but it's certainly fair game. Hopefully it won't come to that. Look, nobody wants to see their employees get sick, whether it's in the workplace or otherwise. And employers are working together and using best efforts on a large part to try to ensure that their workplaces are sick, because it's in nobody's interest to have an employee be diagnosed with the virus and then have to shut down the workplace and bring in sanitizing teams and have an instance where other people in your workforce were exposed to the virus and are now taken out of commission and forced to quarantine for the mandatory 14-day period.
One of the things that we've seen in our consulting practice is that you have this switch that goes from where security was, making sure the doors were locked and people didn't gain access to it, and you controlled access and watched video and that sort of stuff, to then it got to, the health and safety. And for us, health and safety had always been, the trip and falls and that sort of stuff. Today we're looking at where you have security getting more involved in the health and safety aspects of it, and I'm more concerned now with, using hand sanitizers and wearing PPE. That seems to become problematic because we're asking an untrained staff to get involved in a medical component. And so it's sort of, two pliers where I'm going with it. One is, what level of training or how important is it to document at least the level of training that you're giving to employees with respect to, making sure that you've covered all of your bases. And then, part two is, we touched on it briefly before about, the cameras, the thermal imaging cameras, and getting all of that data. When we're looking at that data, does HIPAA start to apply?
The governmental protocols that we were discussing mandate that employers train their employees in appropriate safety measures, and that there are postings that alert employees as to what's appropriate. And your point is a very good one, in that we're dealing in situations where we have people who are not security professionals, not medical professionals, who are being asked to step outside of their comfort zone and take on tasks that they're not qualified to actually perform. And this is a big issue with these thermal imaging cameras that take people's temperatures. And as I said earlier, there's a far cry between these thermal imaging cameras that are certified, that have 510K certification from the FDA, which you certainly can speak to, and a handheld type camera that you purchase in a five and dime and have employees take their own temperature with. And that's why it's important to have appropriate security consultants or people who have the expertise, such as you do, to be able to examine what it is that's being offered to the employer or to the workplace, so that appropriate testing equipment can be brought in. Because not all thermal imaging cameras are created equally.
Oh, that's true. I mean, and some of the testing that we've done with some of the cameras, and it's just you're not getting the throughput that you would need. First up, the camera isn't all that accurate to begin with. If you're looking at a half a degree either way or 3/4 of a degree, and some of them are even more than that. And when you're looking at a specific point of 100.4. And now all of a sudden, you got a camera that can shift in 1 degree in either direction. It's what's the use of it?
Well, that's the problem. The use of it becomes futile. We were talking earlier about one of the companies that we're aware of, FLIR Systems, that actually has a defense background, and that has people from the Defense Department that are actually principals in the company, and they have infrared thermal imaging that works at a sophisticated level, and that can be calibrated to the environment. Not all the systems do. Not all the systems are of the same quality, and that's not an endorsement for one system over another, but the point is that there are a lot of players out there in the field, and it's important for people to consult with consultants such as yourself who have the ability to be able to look at this and to be able to say, okay, we understand this, let us explain this to you, so that you're in a position to be able to make an adequate determination.
Well, yeah, I mean, Jim, I know you got points on this. How many times, and we're going back to what I said in the opening, where 93, 90, with with the bombings in the Trade Center and then the 9/11 attack, the technologies that came out and the rush to be able to bring technology to bear. And how many times today are we seeing, when people are bringing us technologies to take a look at, how many of them are just being shoehorned in, right? You have an access control system, and, the big thing now is everybody wants to have, facial recognition, temperature sensing, and
Right.
access control all rolled into one. The temperature sensing, that thermal imaging camera was never conceived in the original designs, and now all of a sudden they're shoehorning stuff in.
Well, in the security industry, we talk about multi-factor authentication. Before COVID, multi-factor was considered to be, who you are, what you have, what you know, to validate, your identity and your permission to get into a building, and whether it's through passcodes or PIN codes or whatnot, in addition to your credentials and what have you. But we're really looking at another factor of authentication here to validate that you're not ill. And the thing to not completely jump to is that that's the only factor to consider. We can't lose sight of the fact that the security systems are necessary for making sure that the wrong people are not granted access, into the building. When we add this other element, we got to be careful that it's just not let's just take your temperature and figuring that that's going to cover it. I think what we will see evolve here are a number of elements to the health factor that, it would be best if that were, driven by guidelines from CDC or what have you. But it's more than just temperature. It could very well be that, we'll evolve to the ability of taking other metrics, like they take when you're in the hospital. They take your blood pressure. They take your they look at your respiratory system. You look at your temperature. I mean, they look at all these different factors because together they're meaningful in an assessment of your health condition. We may evolve to the point where 3 or 4 of those factors merge together, actually do catch 90% of those that are close to or showing symptoms at this point. But we're not there yet with what we have out there in the marketplace. The thing that business owners and building owners need to be cognizant of is always remember why we're doing this, and don't get mesmerized by something that's claimed to be the latest one-shot technology. There's never a single technology that is a one-size-fits-all. It's always an integration of a number of factors together that can reduce, what we call the nuisance alarm rate and the false alarm rate, and make systems more accurate. And then people trust it because, when something is failing 30 to 80% of the time, it's just optics. It's there for public view, but it's really not performing a function.
And come on, what's one of your favorite sayings? Because we can doesn't mean
Yes,
we
because
should.
you can do something doesn't mean you should do something. That's right.
Well, that's largely why in some of the bigger office buildings you see the initial screenings going on now with the temperature checking, and then when someone is found to have an elevated temperature, best practices would be then to divert them to a secondary screening with a competent medical professional.
Right. Well, an even more optimal situation is to be able to have mobile apps that enable people to self-test, right? To some degree, it's an honor system. As that matures, we can maybe get more specific so that it's not just the honor system, but have that pre-screening to at least mitigate the number of people that you are bringing into that environment that are at risk of, tripping the bell and showing some symptoms that are going to then cause a go, no-go problem. Because that's not where you want the vetting happening, is in the lobby of your building.
Right. Well, there are pre-screening health questionnaires that employees are being asked to complete before coming into the office each day, where they're asked about the various symptoms of COVID-19, whether they have them or whether anyone in their household has them. The problem with some of those screening questionnaires is they ask questions, for example, have you experienced shortness of breath? Now, someone who's got COPD or asthma might always answer yes to that question, and then theoretically be barred from the workplace. And for an employer then to be put in the position of saying to the employee, is there some other basis for why you're you're saying this is impermissible because it's a medical inquiry. So this disease that we're dealing with now raises a whole host of issues that we've never had to address before.
Sounds good. Okay, we just want to take a couple of seconds again just to remind everybody that you're listening to the Risk Advisor podcast, being hosted by Jim Henry and myself, Sal Lafreri. We're going to invite you to comment on our blog at theriskadvisor.com and to subscribe and follow us on our social media like Facebook, Instagram, and Twitter. If you're interested in having one or both of us speak at an upcoming event, or you'd like to consult with either of us or both of us, we're going to ask you to go to our webpage again, and that is theriskadvisor.com to set that up. As we get into the final segment of the show, one of the things that I always like to do is talk about some solutions that the listeners who are dealing with these issues can contemplate and maybe actually put into use. And along that line, I think we should talk about some critical steps in handling COVID, dealing with that situation in the workplace. And one of the first things you had mentioned, you said early on in pre-pro, was think strategically. Tell us a little about that.
Well, look, employers need to address the situation. They need to become familiar with the rules and regulations, and they're changing on a daily basis. And they have to recognize that it's necessary to seek competent advice of professionals who are schooled in this area, whether that means legal counsel and understanding the rules and regulations, and professionals such as yourself who deal with security-based and consulting issues. That's very, very important. And then once the employers actually have taken that initial step, they need to make a determination as to what they're going to do and communicate that to their staff so that the employees know.
Before we get to communication, let me just go back 1 second. The large companies that have the opportunity to have an HR department,
right?
You can turn to your HR professional and hopefully be guided by what they say. Although it's been my experience that HR has always seemed to bring up more questions than they have answers for. But that's just my own personal experience with them. But if you don't have, in the absence of HR, and you're not a large company that has an in-house counsel, what's the best way for them to go?
In terms of what? Trying to determine what to do?
Trying to get the appropriate advice.
Most companies have legal counsel, and most legal counsel can direct them whether they have someone who's an employment specialist, such as myself, or they work with people who have expertise in this area. There are numerous laws that are impacted by this virus. It's not just the safety protocols that are issued by the government. As we were discussing earlier, there are aspects of discrimination. There's confidentiality. There's a wage and hour. It goes on and on and on, and liability issues. And so that's why it's very important for people to seek advice of professionals when they're moving forward.
So for them not to go alone.
Exactly. Read through the government's website. You can read on the CDC, the Department of Health. The governor's page gives very good information as a starting point. But employers have an obligation to become familiar with all these different things, and they should seek competent counsel when they're moving forward if there's something that they don't understand.
And when I was cutting you off, you started to explain about communicating.
Right.
How important.
Employees should feel free to communicate with their employer about concerns that they have. As I said earlier, it's in everybody's interest for people to work together and to work cooperatively, and for the staff to be happy, and for the economy to restart without having a backsliding due to an increase in the virus. So that's the hallmark of any employment situation, is that employers need to effectively communicate their policies and procedures to their employees. And if employees have questions or concerns, they should raise them with their employer, because most of the time employers want to work cooperatively with their employees and have things run smoothly, because it serves everybody's interest.
I would say that in addition to communicating persuasively, it'd be communicating consistently and repeatedly.
Yes.
Another phrase I love is, it's the importance in communication, it's frequency, not amplitude.
Right.
And especially in this case, and especially with the backdrop, I mean, one benefit that employers have, it would be hard for them to appear less competent than agencies like the WHO, and the way that we started with this whole process, where every day was, a different, retraction of a statement or a condition or what have you. So the employers have the headwind of this being a very subjective and indeterminate situation, but they have the backdrop of people knowing that they're trying to follow what is a moving target with what the agencies are giving them. So all the more reason for repeated communications, even if something hasn't changed. Communicate that it hasn't changed, because that actually now is the exception rather than the rule.
Right.
Where it seemed like the news, when we were in April and March and April, was changing, daily of do this, don't do this, wear the mask, don't wear the mask, blah, blah, blah. It's very challenging. So, like I say, the employers have a tough act to follow. But I think if they are very proactive, and if they communicate consistently, and not only indicate what they're doing, but why they're doing it, is very important. Which then
Right.
takes us to the last bullet of when they do take an action, is to act decisively. And, can you elaborate on that?
Right. Well, that goes to the communication point. If they've made a decision as to how they're going to proceed, they need to disseminate that information to their employees and stick to it.
Right.
If an employer is telling their employee, you must wear masks in the office because that's what the guidance says, it has to enforce that policy.
Right.
And make sure that employees are complying with the policy, and employees who don't comply with the policy have to be addressed.
Right.
And if that becomes really a disciplinary issue, because the notion is we want everyone to work together to keep everybody safe.
Right. As long as the employer is clearly indicating that that is a condition of employment, and they are enforcing that equally across the board, they're on good footing.
Well, it's not only a condition of employment, it's a condition of daily life now. Because the governor has said everyone should be wearing masks when they're in public. And when you're in an office setting, it's a quasi-public setting to the extent that you're not in your own individual office with a closed door. So everyone has the obligation to adhere to these safety protocols that have been put into place.
What about companies that bring in outside vendors? We see this a lot, obviously, in the security industry, right? What about the outside vendors that are brought in that are basically having control of it's their employees, right? That are providing the service for your firm. What kind of review, policy, protocol? How do you? I'm stumbling through the question. Do they have? Is the owner of the company who brings in a security guard firm, he or she ultimately responsible for ensuring that the protocols that outsourced service is providing is being maintained?
When someone comes into a workplace or any company, the employer or the person who brings them in has a duty to enforce the safety rules. So would be in a position of saying, to the let's use an example. Someone comes in to fix the copy machine. The person who's fixing the copy machine should adhere to the same safety protocols that the employees are adhering to. Meaning they must wear a mask, they must social distance, the equipment has to be sanitized, those sorts of things.
And separate and apart from it, it's any of those other issues. Does the owner of the company, is there anything they should be concerned about when they're hiring the security company and ensuring that that company has protocols in place?
They certainly could, during the course of the hiring process, say we want to be assured that, in fact, you adhere to all safety protocols relative to COVID-19. And we're seeing that a lot of contracts nowadays do have provisions that are being put in them. As we said, this is impacting so many areas. It's not just employment law that this impacts. This cuts cuts across the board. A little thing like, for example, somebody may have completed many years ago a do not resuscitate order, right, or a living will, saying that they don't want it, they don't want extraordinary means that might have included being put on a ventilator. Well, that might have applied in a situation where someone was God forbid, in some sort of a deadly accident where they said that they did not want to be in that situation. But perhaps now with the coronavirus, you don't want that in place because you want the chance to be ventilated and survive. So those are all sorts of things that individuals have to consider. Just an example of how things going forward are going to be changing. Cybersecurity is a big issue now as people buy more things online. So the list just goes on and on and on.
Yeah, and I'm sure it's got to overseas when you're dealing with, because now you're dealing with global issues.
Right.
Yeah,
That's exactly right. Exactly right. Companies are restructuring. They're going out of business. These are, rent issues. People have been unable to pay their rent. There's commercial leasing issues. It's unending.
Unfortunately, speaking of ending, we have to end. On behalf of Jim and myself, thank you for doing this. We really appreciate you taking the time and coming in today and chatting with us. For those of you that are listening to this, on our website, we will have in the show notes, we're going to have a video that we did, sort of an extended talk with Helen talking about some of the topics, and we invite you to go and download that and take a look at it and give us some feedback on it and tell us what you think. We'd like to say that you've been listening to the Risk Advisor podcast that's being hosted by Jim Henry and me, Sal LaFruary. We'd like to ask you to subscribe to this show and like us on our social media sites like Facebook, Instagram, and Twitter. If you're interested in having one or both of us to speak at an upcoming event or would like us to consult, please go to our webpage, theriskadvisor.com, and set that up. Also, if you happen to know someone that would make a great guest, please go to our webpage at theriskadvisor.com and make your suggestion to us. And remember that you can hear the show on your favorite podcast platform. You can hear it at YouTube and, of course, stream it at theriskadvisor.com. Thanks again for listening, and we hope you tune in next week.
And I would just like to add in closing, of course, anything that we've said here today is not in the context of legal advice. We're happy to discuss these issues with you, but anyone who has questions on any of these areas should consult with their own counsel.
Sounds good. Very good. Thank you very much.
Thank you.
theriskadvisor.com